Right, hello, good morning and welcome to everyone. This is the latest edition of the Radcliffe Chambers Private Client webinar. I'm joined by Emma today, and Emma and I are going to be giving a couple of presentations on 1975 Act claims, and we've called the talk Till Death Do Us Part, and I'm going to be dealing with issues of divorce, settlements and death, and Emma's going to be dealing with cohabitation and death. We hope to address you sort of 20-25 minutes each, and there might be a bit of time at the end for questions if you have any. And afterwards, if you'd like a copy of the slides and the paper, I believe that Chambers are going to send those to you. So without further ado, I'll hand over to Emma, who's going to be talking about cohabitation and death.
Great, thank you, Dan. As Dan's introduced, this is a talk, so today I'm going to be talking about cohabitees and death. And really this talk comes on the back of the Women and Qualities Committee report that was published on the 4th of August 2022. So that report was on cohabiting rights, and the report noted that cohabitation is actually the fastest growing family type in England and Wales. I think approximately 3.6 million cohabiting couples in 2021. The report itself also noted that many people still believe in this common law marriage myth, and this is the belief that after a certain amount of time living together, cohabiting partners have the same rights and responsibilities as a married couple or those in a civil partnership. And this belief can obviously have quite significant consequences for those who cohabit, because though married couples and civil partners have significant rights and responsibilities after divorce and death, cohabitants generally have inferior protection. And if we're looking at the circumstances after death for cohabitation and in comparison with marriage and civil partners, a cohabiting couple will not have the same automatic right to inherit on intestacy, for example, as with those who are married or in a civil partnership. So the surviving partner is going to have to bring a claim under the Inheritance Provision for Family Independence Act 1975. And to do so, they're going to have to show that they meet the eligibility requirements and that the intestacy or the will doesn't make a reasonable financial provision for them. The report itself made several recommendations. In particular, it said that it recommended that the Law Commission proposals from 2011 on cohabitation be implemented, so that there were better rights for cohabiting partners, and also that the inheritance tax regime be modified so that it had the same application for civil cohabiting partners as it did for married couples and cohabiting partners. So that's really the introduction to my talk. Today I'm going to be looking at what rights there are actually available to cohabiting partners, because the government rejected those recommendations by the Women and Equalities Committee. And in particular, I'm going to be looking at the eligibility requirements for cohabiting partners. As a brief aside, there are other claims that might be available, for example, common intention constructive trusts and proprietary estoppel claims. But for the purpose of this talk, I'm looking at 1975 Act claims. So there are two ways in which a cohabiting partner might be able to bring a claim under the 1975 Act. The first is under section 11BA and 1A of the 1975 Act. So this is sort of the cohabiting requirement. And the second one, which I'll come on to deal with later, is a dependent claim of someone who's being maintained by the deceased before the death. Now, if the applicant meets these eligibility requirements, then they can obviously bring the claim for reasonable financial provision. But when the court is looking at whether the will or intestacy made reasonable financial provision, obviously it's limited to maintenance. Again, another distinction with those who are married or in a civil partnership, where it's much more generous. It's not limited to maintenance. So to claim under section 11BA and 1A, the applicant needs to show that they were living in the same household as the deceased and living as if they were a married couple or civil partners, and that this was for the whole period of 2 years, ending immediately before the deceased died. So I'm going to break each of these down. So first is living in the same household. This doesn't always cause a problem because sometimes, generally speaking, cohabiting partners tend to live together at the same address, and there can be evidence of this, direct evidence such as bills, voting records, or utility correspondence, or just other correspondence in the applicant's name. But the actual term that we're looking at is household, not house, not the sort of physical location. And we get some guidance on what this means from Lord Justice Ward in Gully and Dix, where he said, thus they will be in the same household if they're tied by their relationship. The tie of that relationship may be made manifest by various elements, not simply their living under the same roof, but the public and private acknowledgement of their mutual society and the mutual protection and support that binds them together. Where there can be problems and challenges is where the two partners are each maintaining two separate properties. There's no bar to a claim by a cohabiting partner where there are two properties, but the applicant will have to show that notwithstanding two houses, there is one household. If there are two households, then it's more likely that the claim itself is going to fail. And there are two particular cases that I thought worth talking through today. So the first is Kopke and Safarini. This is a Court of Appeal case, and it looked at the wording of living in the same household under the Fatal Accidents Act. So in that case, the claimant and the deceased, they each had a property. One was in Sheffield, one was in Doncaster. And when they first got together, they lived at their respective properties, but they would tend to stay with each other at weekends. And then the deceased got a job in London and he would travel there during the week. At the weekend, he would return. And if it wasn't too late, he would go and stay with the claimant at her property. If he was late back, then he would stay at his own property. And although they discussed getting a house together for some time, they didn't do so because one of the properties was in negative equity. So the court was looking at when the partners could be said to have actually started cohabitating together to the threshold that was required by the Act. And in particular, the Court of Appeal said that the question was whether it could be demonstrated that, albeit they retained a separate domestic establishment in the house in which he had lived for some years, the deceased had effectively moved to live under the same roof as the claimant, leaving aside illness, holidays, work, and other periodical absences. And the court went on to look at this term household and what it actually meant, and said it was quite an elusive term because it almost had two meanings. So the first was sort of the physical connotations, so a place, a physical place, and the second was a more kind of personal connection, the residence within the property. And in principle, the Court of Appeal reiterated that it didn't stop a person from being a member of a household, even though they had a home elsewhere that they would temporarily go to and stay. But looking at the facts in this case, the Court of Appeal agreed with what the first instance judge had found, which was that in the 2-year period, the partners had not actually satisfied the cohabitation requirement. And what was important was almost the time that they had spent at each of their respective properties. So they would stay periodically with each other, but the deceased was continuing to maintain his own property. He left his possessions there, his wardrobe was there, and when he stayed with the claimant, he would live out of an overnight bag. He continued to treat his own property as the address for voting and for employment purposes. Another factor that the court thought was relevant was that they had only really started discussing moving in together and planning a future together when the claimant found out that she was pregnant. And it was then that they said the centre of gravity shifted. But by that point, it was too late for this 2-year period to be satisfied. And although they shared expenses, shopping expenses, for example, that was insufficient to satisfy the requirements. So that's a case where it failed under the Fatal Accidents Act. In Churchill and Roach, that was a claim under the 1975 Act. There, the judge also held that the claimant in that case did not satisfy the requirements of living in the same household. The claimant had not been in the same household for about a 7-month period in the 2 years. And again, the court said that it's not fatal to a claim that there be two properties, but in this case, not only were there 2 separate properties, there was what the court said 2 separate domestic economies and 2 separate establishments. So there wasn't this coming together under one household. And though there was a degree of sharing again, like in Kopke and Zaffarini, so they would share expenses when they stayed with each other at the weekend, that again wasn't sufficient to show that they were living in the same household. And the judge provided an opinion on what was living in the same household in his view, and he said, it seems to me to have elements of permanence, to involve a consideration of the frequency and intimacy of contact, to contain an element of mutual support, to require some consideration of the degree of voluntary restraint upon personal freedom each party undertakes, and to involve an element of community of resources. None of these factors of itself is sufficient, but each may provide an indicator. So that is the first requirement, living in the same household. The second requirement, the applicant has to show that they were living as if they were married or in a civil partnership with the deceased. There has been some guidance from the courts as to what this test involves, but essentially it's quite flexible, and that's to reflect the fact that relationships are very varied. So it's hard to, I guess, pinpoint exactly what it means. We have Reed Watson, where Neuberger gave some idea of what the court's going to ask itself. In that case, the claimant and the deceased had a relationship for about 30 years together. They didn't initially live with each other because they were both looking after their respective parents, but they came and lived together in one household for about 10 years. The question that Neuberger said had to be asked is whether, in the opinion of a reasonable person with normal perceptions, it could be said that the 2 people in question were living together as husband and wife, but when considering that question, one should not ignore the multifarious nature of marital relationships. So in that case, the claimant has said, people that looked in on us, they would have thought we were husband and wife, and the court was inclined to agree with that in that case. And this was notwithstanding the fact that for the last 10 years, there was an absence of any sexual relationship between the partners. One requirement that seems to be stressed by the courts in some cases is that the relationship has to be publicly acknowledged to the wider world. Baines and Hedger was a case where the court considered the relationship between 2 individuals, Mary and Margot, but the court thought that the relationship between those individuals was hidden and unacknowledged. So even though some family members knew what was going on, some might have had some idea, there were others who had no inkling. And the judge said that it's not possible to establish two people have lived together as civil partners in that case if they are not acknowledging their relationship to the wider world. And it was Lewison, who was the judge in that case, he referred to a previous case of South Housing Group and Nutting, where the recorder in that case had provided a list of 4 signs to point towards whether a couple could be said to be living as if they were married or in a civil partnership, 2 of which were emphasised on appeal. The first one is that there's this lifetime commitment. So you have to look at whether these are 2 people coming together in a relationship that is permanent, an emotional one, and it's separate from relationships of convenience, friendship, students in a flat share, for example. But then that lifetime commitment requirement is subject to a further qualification, that relationship is openly displayed to the outside world. So that is the second requirement. One point, I suppose, that would be interesting if the court's ever looked at this is the approach towards relationships which are more polyamorous. So if there are a group of people living in one household in a sort of open relationship, whether that could ever qualify living as if they were married or in a civil partnership. Looking at the third requirement, so 2 years before death, the cohabitation has to be for the whole 2-year period, but the courts generally take a pragmatic approach towards this time period. So in Re Watson, the deceased had been in hospital for 3 weeks before his death. The defendant, who was the Treasury solicitor, didn't take the point that, or didn't argue that this would prevent the applicant from claiming under the Act. And the court recorded that would have been an argument that would not respectively have been advanced. So being in hospital obviously doesn't prevent you from being part of the household. Again, there's an emphasis on this concept of household rather than physical location. In Gully and Dix, another case that considered interrupted cohabitation, Miss Gully, she had cohabited with the deceased for a long period, but she left him as a result of his behaviour and lived apart from him for, I think, the last 3 months of his life, and he died. And then the court found that she could have still been living with the deceased, notwithstanding they were living separately in 2 separate locations. What the question for the court is whether that relationship is still continuing and it hasn't actually irretrievably broken down, or have the parties actually recognised that relationship is at an end. If the relationship and the interruption is just temporary, but the relationship is still continuing on, then they're still living in the same household. So in Gully and Dix, the court was satisfied that the relationship hadn't come to an end, and that Miss Gully would have actually gone back to Mr. Dix the moment that he asked her to. This was a relationship that had been through some quite bad times, and the court was satisfied that it was still continuing. Another relevant case is that of Kerr and Dallowell. So in that case, there was a lengthy period of about 10 months where the partners weren't living together, but only 3 weeks of that was actually within the 2-year period. And the court found that the time period was satisfied overall. It was quite an interesting or exceptional case on the facts, because the deceased had been married for 25 years, and then his wife had committed suicide, and he had been charged with manslaughter, which he was later acquitted. And he met the claimant a few months after the death of his wife. He met her in, I think, May 2005, and they were engaged a month later, and they were living together, I think, before the deceased's death for about 1 year and 49 months. So there was a 3-week break. But there was an earlier point in time before the 2 years where they had also been living together. And the court in that case referred to the judgment in Gully and Dix and what the court had asked itself, which is, whether this relationship is continuing, or whether both parties have realised that it's come to an end, and or whether it's sort of temporary. There's a temporary break in the living together. And the judge in Coe and Dallywell, the appeal judge, found that the first instance judge was entitled to find that the parties had the settled relationship, and that the settled relationship had continued up until the deceased's death, and that it satisfied the 2-year period. Now, even when there was this break of 10 months in the 3-week period in the 2 years, the deceased and the applicant, they saw each other every day. So they worked together at the same cafe, apart from, I think, a period where the deceased went abroad. Their engagement to marry was continuing throughout. But more focus seems to be placed upon the fact that of their relationship, and that's continuing, than of their physically being in the same location and under the same roof. So that's the criteria for claiming as a cohabitant. One area I think would be interesting to see whether it has any effect is what the coronavirus pandemic has had on cohabiting partners, if people have been isolating together, and whether there'll be any continuing effect, as we see in litigation from that. So once the applicant has satisfied the eligibility requirements, the court will then ask whether the will or intestacy has made reasonable financial provision, and if not, what ought to be made. And as indicated at the outset, this is limited to maintenance, so it's not everything that the applicant would like to have, that would be desirable to have. It's day-to-day expenses, and the court is going to be interested in the standard of living that the partner had with her cohabiting partner during the relationship. So where the standard of living is high, it may be that there's a better claim for more provision from the estate. And looking at whether there's the issue of reasonable financial provision, the court's going to look at all the Section 3 factors. For cohabiting partners, there's the specific Section 3 factors. These are fairly straightforward, but include age of the applicant, length of period of cohabitation, and contribution made. So there's likely to be some overlap when looking at this factor as looking at the eligibility requirements. The next way in which a cohabiting partner might be able to claim is as a dependent under Section 11E. And this is going to be helpful if you've got a cohabiting partner where the cohabitation is under 2 years, there's no evidence of that they were sharing a household, and where they haven't been living together as if they were a married couple or civil partners. So the criteria for this is that immediately before the deceased's death, the applicant was being maintained by the deceased. It's possible to bring the claims in the alternative, so the cohabitation and the dependence claim. What does being maintained by the deceased mean? Well, we have an additional section to assist with that definition. So Section 1.3 tells us that a person is to be treated as being maintained by the deceased if the deceased is making a substantial contribution in money or money's worth towards the reasonable needs of that person, and other than a contribution made pursuant to commercial nature for valuable consideration. So just briefly looking at these in terms of reasonable needs, there's going to be a lot of overlap with the Section 3 factors, where you're looking at financial needs of the applicant, housing, food, clothing. In Re Watson, the court was considering the fact that the applicant in that case, she had her own empty house, which was in the same town as the one that she was living in with the deceased. She said she was being housed by the deceased, and the court said that the caution should be taken before concluding that someone who already has their own housing has a housing need. Maybe a different outcome if the house is in a different location, for example. So if the applicant has a property elsewhere that's not going to satisfy her housing need, or if it's tenanted, for example. In terms of other points on reasonable needs, there's a case where social activities, alcohol and cigarettes and petrol weren't considered to be a contribution to a person's reasonable needs. Possibly in a different case, a different result. So, I mean, petrol, for example, people need travel expenses. Indeed, when you look at the Section 3 factors, you often have a list of various things that the applicant is spending money on, and travel and petrol can sometimes be one of them, as can social activities as well. But in that case, it was not said to be reasonable needs. The commercial nature of the contribution in exchange, that distinguishes them between previous law, where the courts had the task of having to weigh up different domestic benefits against each other. So where one side was providing housing and the other was providing care, for example, whereas now it's just consideration pursuant to arrangement of commercial nature. And so, for example, if there's a paid carer, for example. Finally, if the claimant can succeed, can bring a claim under the dependent category, then again there are specific Section 3 factors to consider. These really look at what was the deceased doing for the applicant, for how long, and why the deceased was doing that as well. So that brings me to the end of my talk on cohabiting rights. I'm going to pass you now over to Dan, who's going to talk about divorce against death.
Thank you. Right, so my talk today is slightly clickbaity, and it's entitled Divorce versus Death. And what I'm going to be talking about is really the relationship between financial provision in divorce settlements and financial provision upon death. In reality, it considers what happens when the two clash, and specifically is illustrated in the recent case of Sismay and Salandran, which I hope some of you are familiar with. And in particular, I'm going to be considering the increasingly common practice of spouses including testamentary obligations in matrimonial finance settlements, and the effect this has on subsequent claims under the 1975 Act. And before I deal with the problem and its solution, it makes sense to just deal with the legal framework. So in the first instance, the concept of testamentary freedom is paramount. And this is perhaps best explained in Williams on Wills, where it says, although a will is by its nature always revocable, yet a testator may bind himself personally and as to the contents of his will, and may bind his asset so that his personal representative, whether he dies testate or intestate, must give effect to such agreement at the expense of the beneficiaries. And it's important, however, to note that in such case, there must be a binding agreement by the testator to dispose of the property in a certain way, and it requires two certainties. One, that there was an agreement in law and not just merely a statement of intention, but secondly, it must be shown with sufficient certainty what the subject matter relates to. So it's against that background now that we come to the two sort of stooges of divorce and death. And obviously family practitioners will of course be familiar with the provisions of the Matrimonial Causes Act 1973, sections 21, 21A and 23 to 24A of which provide the court with the power to make various types of award in a claim by a spouse for financial provision for that spouse, but also on behalf of children of the family following a divorce. And the suite of relief includes, for example, periodical payments, a lump sum payment, property adjustment orders, a pension sharing order, and also an ability to vary a nuptial settlement, whether it's a prenuptial or a postnuptial, including one made by will or codicil. But crucially, the family courts do not have power to direct that a spouse enter into a testamentary arrangement, i.e. execute a will or codicil, leaving property specifically to the applicant or the children of the family. And that's not included within the suite of remedies contained in the 1973 Act. The family courts quite reasonably insist on parties to financial remedy proceedings engaging in ADR, and in practice, the vast majority of applications are concluded by way of consent. Nevertheless, any consent order ought to be properly scrutinised by the court before being approved. And this was explained by Mr. Justice Thorpe in the case of Peacock and Peacock, where he said that it's beyond question that such orders are not made simply upon the evidence of the applicant's consent. The court has an overriding duty to survey the sufficiency of the proposed consideration and the overall fairness of the orders proposed. So that's divorce. Fast forward to death, and obviously private client practitioners will be familiar with the 1975 Act, and Emma's very helpfully gone through certain relevant provisions of that in relation to cohabitants. I'm just going to give a very brief overview in the context of what I'm talking about today. And obviously the 1975 Act permits a qualifying person to make an application for financial provision from the deceased estate on the basis that the devolution of the estate is not so as to make reasonable financial provision for the applicant. And so in summary, spouses, former spouses, children of the family or treated of the family, persons being maintained, and of course cohabiting partners, as we've seen from Emma's talk, can all apply under Section 1. Now, the court has very wide powers under Section 2 to make orders if it considers that the will or intestacy are such not to make reasonable financial provision for the applicant. Now, the court must obviously have regard to a range of factors in Section 3. These are the famous gateways. They include the financial resources of the applicant, the financial resources of the beneficiaries, the obligations and responsibilities of the deceased, the size and nature of the estate, and disabilities. And there's a catch-all gateway for any other matters. Now, generally, as most of you know, spousal claims will be subject to a higher standard, so the divorce fiction, but all the other claims where the relevant test is financial provision is such as would be reasonable in all the circumstances of the case for the applicant to receive for their maintenance. And that's, of course, the maintenance test that Emma dealt with in her talk. So that's the legal framework. Here is the problem. So the problems caused by the manner in which claims for financial provision and applications under the Matrimonial Causes Act 1973 increasingly are being compromised. Specifically, as part of a suite of relief, the respondent spouse will provide an undertaking to the court to execute a deed of covenant in the form appended to the order. That deed of covenant will require the respondent to leave by will or by codicil their entire estate to a combination of the former spouse and the children of the marriage in expressly defined shares. So it essentially seeks to tie up the respondent spouse's estate in the future. Now, the threat of the undertaking ensures that the deed of covenant is executed. If it isn't, you can go to court to enforce the undertaking. And once the deed of covenant has been executed, then the following principles apply. Firstly, the covenantor is obliged to ensure that upon their death, there is a will or codicil bequeathing to the spouse and the children of the family the estate in the agreed shares. Now, if the obligation has been complied with, then the covenantor's estate is nil. If the obligation hasn't been complied with, then there lies an action against the personal representatives of the estate for specific performance or damages in lieu, or otherwise that the property is held on trust. And there's a Privy Council case from 1972 called Schaffer and Schumann, where the Privy Council held that in those circumstances, the property is held on trust for the covenantee. So the problem arises when the covenantor subsequently enters into another marriage or has children or enters into any of the multifarious relationships which give rise to a right to apply for reasonable financial provision under the 1975 Act. And specifically, the problem is that the deceased property is already tied up by way of the provisions of the consent order and the deed of covenant. And a common factual scenario is where the former spouse, or the covenanter, complies with the consent order by executing the deed, and then complies with the deed by executing the will, but later remarries. And of course, the effect of remarriage under Section 18(1) of the Wills Act 1837 is for the will to be automatically revoked. So in those circumstances, upon the covenanter's death, the estate will devolve on an intestacy, and the surviving spouse will take the majority interest along with any of the deceased children, whether they're children from the first marriage or the second marriage or any other relationship. So the estate would be subject to a claim from the covenantees, which will effectively reduce the estate to nil, and thus the new family has no assets against which to claim. So that, in a nutshell, is the problem. Is there a solution? Well, it appears that the drafters of the 1975 Act thought about this kind of scenario and sought to provide a solution in the form of the various anti-avoidance provisions found in sections 10 to 12. Now, most practitioners, including myself, spend a lot of time in the 1975 Act, and we don't usually jump into sections 10 to 12. And every time we do, certainly in my case, I'm astounded by how complex they are. Unfortunately, the solution to this problem requires us to grapple with these provisions. So they're complex, but in essence, Section 10 relates to dispositions intended to defeat applications under the Act. Section 11 deals with a slightly different scenario, which is contracts to leave property by will. And then Section 11 deals with supplementary provisions. Now, I'm just going to take you through the summary of the provisions. I have set these out in more detail in the paper accompanying this, and a copy of that will be sent out if anyone wants any further punishments. Section 10 and Section 11, the important point here is that the claimant in a 1975 Act application must make another application within, usually in the claim form, for an application under this section, either Section 10 or 11. In respect of Section 10, in subsection 2, the court says that, well, 3 conditions must be satisfied in order to make an application under these anti-avoidance provisions. And in respect of dispositions intended to defeat applications, the 3 conditions are these. Firstly, that less than 6 years before the date of death of the deceased, with the intention of defeating an application for financial provision under this Act, made a disposition. So you have to have a disposition with the intention of defeating an application being made subsequently. Condition 2 is that full valuable consideration for that disposition was not given by the person to whom or for the benefit of whom the disposition is made, that person being the donee. And thirdly, that the exercise of the powers conferred in the section facilitate the making of financial provision for the applicant under the Act. Now, if you get through the first 2, you usually qualify on the third, it seems to me, especially in the scenario we're looking at here, where there is simply nothing in the estate at all, and but for an application under this section, it would be very difficult to get any relief. So if the conditions have been satisfied, then the court may order the donee to provide such sum of money or property as it so chooses, but the property must not exceed the sum or the value received. So there will be a sort of weighing up process of the value of the consideration. And importantly, and perhaps adding further layers of complexity, when faced with an application under Section 10, the respondent of that application may themselves make an application if the deceased has done something similar. So you can bring into consideration other dispositions made by the deceased which meet the test, and the court will have the power to include property in any award. And that makes sense, because if there's one deed of covenant to one party, but the deceased has done it to others, then it makes sense for the court to have regard to the circumstances in which any disposition was made, any valuable consideration which was given, the relationship, if any, between the donee and the deceased, the conduct and financial resources of the donee, and all other circumstances of the case. And it seems to me that in all other circumstances of the case, you would look at the Section 3 factors as well. So that's Section 10. Section 11 obviously deals with contracts of any property by will. It's drafted in similar terms, but it's not identical. There are actually 4 conditions for making an application under this section. Firstly, that the deceased made a contract by which he agreed to leave by his will a sum of money or other property to any person, or by which he agreed that a sum of money or other property would be paid or transferred to any person out of his estate. So it's not just a contract, but it's also an agreement as well. The second condition is that the deceased made the contract with the intention of defeating the application. So again, there's an intention requirement. And thirdly, that when the contract was made, full valuable consideration for that contract was not given or promised by the person with whom or for the benefit of whom the contract was made, also known as the donee. And then finally, that the exercise of powers conferred would facilitate the making of financial provision of the Act. So it's similar, but not identical. Now, again, if the court is satisfied, any order could be made directing the money to be used. But if the contractual provisions haven't been complied with, then the court can direct that the contractual obligation is not performed, i.e. it can direct the personal representatives of the deceased estate not to pay money to a covenantee who is alleging breach of covenant. Now, importantly, again, the court may exercise the power only to the extent that it considers that the amount of any sum or money paid or to be paid, or the value of any property transferred or to be transferred, exceeds the value of any valuable consideration. It's fairly fiddly that, but the court has to deal with a sort of weighing up exercise. It might not be a case of total failure of consideration, but if full valuable consideration hasn't been made, the court needs to assess and make a value judgment as to how valuable that consideration is. And in practice, as we'll see, that's a fairly tricky exercise for the court. Finally, there are 4 important supplementary provisions in section 12. The first of which is that the intention condition is fulfilled on either section 10 or 11 if the court is of the opinion on the balance of probabilities that the intention of the deceased, and it doesn't need to be the sole intention in making the disposition or the contract, was to prevent an order for financial provision being made, or otherwise to reduce the amount of any provision that might otherwise be granted. So actually, intention's a fairly low bar. And we'll see that when we come on to the case of Sisme and Salandron. Now, importantly, and this is the second supplementary provision, that where no valuable consideration was given by any person for the contract, it shall be presumed, unless the contrary is shown, that the deceased made the contract with the intention of defeating the application. And that's important in relation to our problem, because where you have deeds of covenant which include provision where a will is executed for the benefit of children of the family, the children of the family will not be applicants or parties to the Matrimonial Causes Act application, will not be parties to the consent order. So therefore, it's quite easy if you're acting for a claimant to argue that no consideration has been given by the children. And it might be the case that shares in the deceased estate, the larger shares, are going to the children rather than the wife who has got significant lifetime provision. So that's just something to bear in mind about getting over the first hurdle of intention. The third supplementary provision is that the court can give such consequential directions as it thinks fit, including directions for making any payment or the transfer of any property, the effect of giving effect to the order or securing a fair adjustment of the rights of the persons affected thereby. So the court will look at the rights of the donee as well, because it's a rather unusual application insofar as it goes through the estate and into the, essentially against the person who is the donee of the property or the covenantee in this case. And then finally, as the saving provision relates, if the donee has died, then the order or direction shall apply to the personal representatives of the donee. But the court will not have power to make an order in respect of any property that forms part of the estate that has already been distributed. But that shall only, and the liability on the personal representatives will only be if they had notice of the application before the distribution. So that's fairly sensible and logical. Again, they're fairly complex provisions. Now, until recently, these anti-avoidance provisions receive very little, if any, consideration by the courts. But the very recent judgment came out earlier this year in Sisme and Salandron changed that. And we've now, for the first time, got a reported example of the court grappling with the problem caused when divorce meets death. And so I'm going to deal with a summary of facts initially. I'll talk to you about the decision, then I'll give you some brief conclusions on the matter. So in this case, the court had to determine claims concerning the estate of the deceased, Mr. Sismo. And the application, there was an application by his second wife, M, we'll call her, for reasonable financial provision, but also cross-claim from the adult son, T, from the first marriage, so that the trial of the action, the court was dealing with two separate claims. Now, T's parents, so the deceased and the first wife, were married in 1988, and the family home had been a residential property. Now, the deceased worked overseas during the early 2000s, where he formed a relationship with M, who lived in the Philippines. And so T's parents separated, and the son moved in with his mother to a house that she'd acquired separately by way of an inheritance. The deceased remained living in the property when he was in the UK, and he and M had a child, J, in 2008. Now, things came to a head when, in 2012, M and J's immigration status were finally resolved. They moved to the UK to live in the property with the deceased. Now, in order to satisfy the UK Border Agency requirements and show them that he was in fact divorcing his first wife, the deceased obtained a decree nisi in 2013. And thereafter, negotiations with the first wife concerning financial remedy proceedings concluded with agreement in 2016. As part of that agreement, we have a consent order, and the family court subsequently approved that consent order. Now, that consent order contained terms similar to which gave rise to the problem, namely that there was a requirement to execute a deed of covenant, and the deed of covenant was executed by the deceased in February 2017, and he was required to gift the property to his son by will, and he executed that will in March 2017. So in this case, it's not a percentage share of the estate, it's a gift of a property in specie. M actually signed the statement on the consent order to the effect that she understood the terms and that she had no beneficial interest in the property. Now, later on, in 2019, the deceased was diagnosed with cancer, terminal cancer, and he married M, his long-term partner. Obviously, the marriage revoked the will under the Wills Act, and so the deceased died intestate. The property formed a significant part of the estate. And obviously, in that case, the surviving spouse had the majority share, but then the infant child, J, but also T, were entitled in accordance with the intestacy provisions. T complained, sued indeed, and sought specific performance of the agreement within the deed of covenant to leave the property to him. Alternatively, he sought a declaration that a constructive trust had arisen. M, however, said, well, actually, the deed's unenforceable because it failed to comply with the formalities requirements of a section of the Miscellaneous Provisions Act 1989. But alternatively, she brought a 1975 Act claim, and within it brought an application under Section 11. The key point here was that there was nothing really left in the estate but for the property. So the property was the key feature, and in her claim, the claimant M said that she wanted transfer of that property. So there were lots of issues at play, and in a detailed 40-page written judgment from H.J. Kelly, sitting as a High Court judge, the evidence was considered, the legal framework, and the following findings were made. So as to the enforceability of the deed of covenant, well, the deed was expressly enforceable by T, the son, who was not a party. That was under the privity and the contract rights of third parties provisions. In any event, construed with the consent order, it constituted sufficient consideration so as to be enforceable under the 1989 Act. So the technical formalities argument was lost essentially, and the judge held that it was a valid and enforceable as against the personal representatives of the deceased estate. It was slightly skated over as to the nature of the remedy. It seems that everyone assumed that specific performance could be granted, but in any event, there's clear Privy Council authority in the case of Schaffer and Schumann that in those circumstances, property is held on trust. It's not clear to me whether it's a common intention constructive trust or a trust created by operation of law, but it doesn't really matter for present purposes. it meant really in the case that the surviving spouse M had to satisfy the test in section 11 of the 1975 Act, because this amounted to a contract to dispose of property by will. For completeness, the learned judge found that, well, had the deed not been valid and enforceable, there was a common intention constructive trust that arose anyway, and it was unconscionable of the personal representatives of the deceased estate to deny the son's interest in the property. Had that been the correct analysis, then section 10 of the 1975 Act would have been the correct provision. But because the deed of covenant was binding and enforceable, and it was a proper contract, it was section 11. So therefore, the judge looked at the applicant wife's claim or application under section 11. Obviously, the first limb, as we've seen, is intention. Now, the judge looked at the contemporaneous correspondence in relation to the settlement of the divorce proceedings and found that it was a material intention of the deceased to defeat any future application for financial provision or reduce the amount of provision which might be granted, so that the first limb under section 11.2 was satisfied. Now, that case, it was actually quite straightforward, because it was very clear from the notes scribbled on the inter-parties correspondence that they wanted to take the house out of the reach of any future claim. The next question, which was more vexed, was full and valuable consideration. And the judge held actually that M had failed to establish that the deceased first wife had not provided full and valuable consideration by entering into the consent order in circumstances where the consent order was actually very favourable to the deceased, insofar as it allowed him to retain his pensions. There was no pension sharing order in full. He kept a large proportion of the matrimonial home mortgage free, and he kept all of his savings. He had to give a share of the joint account. So, taking a step back, it was a fairly good deal for the husband. And so on that basis, the judge said, said to the wife, well, you haven't come up to proof that there wasn't full and valuable consideration. So on that basis, the 1975 Act claim failed and the son's claim succeeded. And so, taking a step back, the judgment in Sidesmay and Salandron illustrates that the questions of detriment, unconscionability, intention, consideration are very factually sensitive, and it will depend on the scrutiny of the evidence by the court. And practitioners really need to get their hands on the divorce file to see, as between respondent and applicant, whether or not sufficient intention is there, especially in respect of any provision given to the spouse, the former spouse, but also whether or not you've got the sufficient consideration. Now, the anti-avoidance mechanisms in the 1975 Act provide, in theory, a mechanism to claim against the assets apparently tied up in these far-reaching and private client practitioners might say fairly outrageous consent orders from earlier divorces. But in practice, however, there is a high threshold, and it seems an applicant will not only need to show the requisite intention, but also there's been a significant oversettlement in favour of the respondent former spouse, or otherwise that there was a sham divorce. And when you're looking at sham divorces and oversettlements, in my view, that's a very high bar. So whilst intention may be apparent sometimes from the inter-parties correspondence, what private client lawyers will need to do, perhaps with the assistance of family law colleagues, is really look at the consent order and work out, actually, is this a case where full valuable consideration is being made, or has actually the applicant in the financial remedy proceedings got everything that he or she wanted? And so my view is that the evidence in most cases actually is that you're not going to reach this threshold. And so for the time being, I think the answer to my title is that divorce trumps death. But I don't know whether Sidesmay and Salandron will be subject to appeal. It seems that the judge and the analysis given was pretty solid. There are a couple of things that weren't really dealt with, but not, I think, on the facts of that case enough to overturn it. So we might have to wait for the next court to deal with sections 11 to 12, but at some stage it would be helpful for the Court of Appeal to look at it. Right, so that's my talk today. I'm very grateful for you all to have sat through that. We've got a couple of minutes left for questions. I'm just going to stop share on my screen and bring Emma back in. Just have a quick look. Sarah, hi Sarah, how are you? Does the intention to defeat a claim have to be an overriding factor, just material? Good question. That's actually dealt with in section 12.2. So it doesn't have to be the overriding factor. It can be one of many. And I think that's why I think the bar to these sorts of claims is fairly low in relation to intention, but the problem lies when you get to consideration. Ziva, hi, let me just read this. If the avoidance of the covenant happens through remarriage, is intention properly demonstrated? I don't think so, because I don't think many people know that getting married revokes your will. I think the relevant intention is the intention at the time when you entered into the disposition or the contract. And so your intention later to try and get out of the consequences of what you've done, I think is only relevant in relation to looking to all of the circumstances and considering the circumstances when the court weighs everything up. But in terms of the gateway, it's the intention at the time. Now, it might be the case that the deceased rather helpfully says, in support of the, say, for example, if someone knows they're dying, they might well write a letter that says, well, look, I entered into this consent order and I did it in order to block a claim. Things have now changed. That's obviously very, very, very helpful evidence. But I think if anyone's got one of these cases, and I'm certainly advising on one at the moment, which is why the idea popped into my head to do the talk, you really need to look at the all of the inter-parties correspondence and try and get the exchanges that were going as between husband and wife at the time. And it's only once you've got all of that that you can then give a proper analysis and try and provide advice as to the merits of the claim. So I think that's it for questions. I'm very, very grateful for you asking questions. I always know at the end of these, there's normally a sort of long silence. But you know, as I said before, if anyone's got any specific follow-up with anything I said or Emma said, you know, you're very welcome to call or email us.
Yeah, we'll put our email addresses on the slides. I think that might be helpful.
Great, brilliant. Well, I think that's about time. Fantastic. Well, look, we're very grateful for you giving up your time this morning to join us on this rather gloomy November day, and we hope you will have very pleasant afternoons.
Thank you very much.
Yes, bye-bye.